SJC-13433, Commonwealth v. Warrens, Gelin.
Okay, Attorney Lynch. I'm sorry, Attorney Murphy. I apologize.
Thank you. Good morning, Your Honors. Owen Murphy for Mr. Warrens, Gelin. Excuse me. Now, I think the first issue in this case is pretty straightforward, and it boils down to the question of whether the Commonwealth can use evidence that it seizes through racially biased law enforcement and then introduce that evidence, thank you, at a violation hearing with the end result of placing somebody in jail and revoking their liberty. And I'd suggest that the very most basic concepts of the Equal Protection Clause and human rights countenance against such a proposition, and that issue is rather straightforward. In regard to the second, so putting individual instances of biased law enforcement aside, the rule prohibiting probationers from moving to—
Counsel, I'm going to interrupt you again, I know that you're here to advocate on behalf of your client, but you're saying a bunch of things that haven't been proven or haven't been tested, and it's your view of the evidence that it was racially biased. I'd like to get back to the main point about whether or not the exclusionary rule should apply in probation surrender matters. And I know you're saying that it's tethered to a different constitutional rule, but just a couple of years ago in Commonwealth versus Rainey, we again reaffirmed our jurisprudence that it doesn't, for a variety of different reasons that have nothing to do with constitutional protection, that the policy reasons behind why we don't apply the exclusionary rule in probation surrender matters continues in force. And we said that just a couple of years ago in Rainey. So why should we say something differently now?
In Rainey, the court qualified it generally doesn't apply, not that it always doesn't apply.
Sure, and that we reaffirmed the same kind of safety valves that we had in O'Brien from the beginning, which aren't applicable in this case. So why is this not the general garden variety reaffirmation of what we've said all the way since O'Brien?
Well, I think what strikes me the most is that—
Olson, excuse me.
Well, one of the reasons in Rainey and a lot of the cases discussing the application of the exclusionary rule, one of the justifications is rehabilitation, right? The idea being that you can place all the evidence in the light of justice for a court to consider when they're considering whether to rehabilitate the probationer that's been found in possession of contraband. So I would suggest to you that that can never really take hold in an instance where the evidence was produced in the pedestal that the court and the probation department are standing on is evidence that was seized through racially biased law enforcement. And the reason being that in an effort to rehabilitate somebody, you need at least some semblance of credibility. And I think that—
Can we just go back to the precise question and address, absent the circumstances held out in Olson and implicated by the generally in Rainey, where the law enforcement officer knows the person is on probation, how can the purposes of the exclusionary rule be advanced when the purpose is deterrence, not remedy?
Deterrence is one of the purposes. I think it's pretty clear from this court's decision that judicial integrity is also another purpose that serves by the exclusionary rule. And uniquely in the case of equal protection claims such as this, there's really nothing to deter. Deterrence isn't an effective remedy because in a case of implicit bias, the officer might not even know that he's acting out of bias. It could be a subconscious action, which deterrence really isn't going to affect. But as I cite in my reply brief—
I thought equal protection requires a discriminatory intent, not implicit bias.
discriminatory intent can take place either consciously or subconsciously. So I think a lot of times it can take place subconsciously without a conscious decision by the actor.
I understand your argument. What I'm looking at, obviously the violation of the law that you posit is equal protection. But what is it unique about that violation of law versus a Fourth Amendment violation or other violations where you said the exclusionary rule doesn't apply?
Because a violation—
We have a police officer who breaks down someone's door, right, and seizes contraband. That's you know, we'll get to what egregious means when we ask other counsel for that, and I'm sure you're anticipating that argument. But anyway, why this constitutional violation?
I mean, they're different harms, right? So, I mean, if you are going to create a rule that says you can't move under the Equal Protection Clause to challenge evidence that's admitted at a violation hearing, that's only affecting one subset of the population. Unreasonable searches can be levied upon really anyone, and I think predominantly they're unfortunately unlevied against minority people, but the fact of the matter is that a biased law, an instance of biased law enforcement is very predominantly affected towards one subset of people. And
I guess I don't understand that. Why is the Equal Protection Clause different than the Fourth Amendment?
Or the Fifth.
Or the Fifth?
Or the Fifth, because in Olson, we cited the Fifth for that same proposition. Why is it different?
I think the Equal Protection Clause by its nature is that it was erected to correct an injustice that was happening upon a subset of the population. So it doesn't, the idea
But
of
when a right was created to correct an objectionable conduct aimed at a particular subset of the population, then the exclusionary rule does not apply? Is that your argument?
my argument is that the exclusionary rule, as it's been interpreted to not apply at probation violation hearings, it simply doesn't mesh with the Equal Protection Clause for a number of reasons, judicial integrity being among them, deterrence being among them, but the right itself is just different in nature from those other rights the court is discussing.
But can you get more granular? You've said that now a few times. What is it about that right that makes it different?
As they talk about, this court talks about in Long and Laura and other cases of that nature, again, the right was established to correct wrongs of the past,
So
discrimination.
that's what I'm trying to get at. Is that the metric that we use when a right was created to correct wrongs of the past, as you say? Then when it's violated, the evidence seized in violation of that clause cannot be used in a probation revocation hearing. Otherwise, it can be. Is that your rule?
My suggestion is I think you just really need to, I'm not sure I completely understand the question, but if you look
Well,
at
it's your position. I mean, I'm trying to figure out your position. You're saying that the Equal Protection Clause is different than the Fourth Amendment, and I'm trying to figure out why. And all you've articulated this morning is that it was a right created to correct wrongs of the past.
And based on the wrongs of the past to correct the wrongs of the future, I should say, would be a more accurate interpretation of it. And this is one of those wrongs.
You
and
don't
I
think the Fourth Amendment was created to correct wrongs of the past?
I do. I just think that it's different of a very different nature when it comes to an unreasonable search, which could happen to anyone, and biased law enforcement. And disparate impact.
You say that, but how? I mean, if you're going to take that position, isn't implicit bias, if not explicit bias, certainly infused in some of the criticisms of search and seizure, reasonable suspicion analysis? I mean, don't we have those same concerns when it comes to the Fourth Amendment and Article 12?
Absolutely.
So again, going back to Justice Wendland's point, I'm trying to figure out what's the difference between the two, because you can make that same argument under Article 12 in the Fourth Amendment that you could under equal protection.
I think this court needs to ask itself if it's just for somebody and under the rule that's promulgated by the Commonwealth, in this case, for an officer to declare his racist intentions, go and search somebody on the basis of their skin or some other classification like that, and then use that evidence to place that person in jail, and whether that meshes with our constitutional rights that we believe in.
Wouldn't it come into Olson, where we look at whether or not there's a egregious police misconduct and known probation violations?
Correct.
Doesn't that cover that situation?
I think that is a different situation where there could be some type of.
So let's have the hypothetical, of course, is right. The police officer knows that this person that they don't like is on probation, and they kick down the door, right?
Right.
For no reason, and they go, gotcha. and then they come to a VOP versus the criminal trial, and they say, well, no exclusionary rule.
Right.
I think that's what Olson basically says and prohibits, correct?
I agree
Is
with that.
true?
I think Olson's broader than that.
And Rainey as well, right?
I don't know that that's really, I'm not sure I would categorize Rainey like that. I think,
Implicitly, when it says generally in Rainey, before getting into the details of the wiretap statute, it's pretty clear that if we've got a horrible of horribles here, that the exclusionary rule is not going to be unable to be utilized.
right, my reading and my understanding of that, the rule or the exception, I guess, in Olson would be that if you have some type of egregious misconduct, then that could open the gate to making a motion to suppress an unreasonable search based on the fact that it was misconduct that led to that unreasonable search. And if you look at this case, if you look at,
No, I thought Olson doesn't deal with exclusion. It just says we're not going to allow that evidence, and this is the violation probation proceedings, correct?
correct. That's correct, but I think there's probably two different causes of action that at least could be theoretically considered when you consider Olson and its discussion of egregious misconduct, but then also Long, which says that we're not going to allow this type of evidence to be permitted in. And that was a criminal case yesterday. However, the reading I get out of Long, the sentiment is broader than that as well.
There's a pretrial situation, though, but I think it's the amici who point out that now as technology advances, it's easier for police officers to know pretty quickly
Correct.
whether somebody is on probation. Why don't you utilize that argument as we think about whether or not the factors in Rossetti are present to reverse so quickly our previous holdings?
Now, I'd actually ask this court to take a look at the second video clip that's on the disc that I submitted to this court. And upon studying that again in preparation for today, it's pretty obvious to me that the officer first learns that Mr. Lockett-Simmons is in the back. He learns that he was just recently released from incarceration, and it's pretty much
the front seat passenger says it, right?
yes, it's disclosed.
That's when he finds out, when the
Yeah.
front seat passenger goes, hey, he just got out. He was just incarcerated, right?
I think Mr. Lockett-Simmons is answering, but the officer can't hear him, and my client, Mr. Gelin, repeats it, yes. But it's at that point when he learns that he was recently released from incarceration.
But I think what would be more problematic for the government would be if they pulled him over with that knowledge, right? They run a
Right.
plate, and it comes back to,
Right.
Gaziano, and they go, oh, this guy's on probation, and then all of a sudden the blue lights come on.
I think you have to look at the totality of the circumstances, and the stop here was, I would suggest, pretty pretextual, but
What do we do with the fact that the driver who was stopped was white? How does that affect the analysis at all? That is, the stop was of a white male, not of a black person.
well, I would suggest that you have to look at the total picture and the idea that a stop takes place. Whether or not that stop was racially motivated, implicit bias can set into the investigation that follows thereafter and the decision-making process that follows thereafter. And I'd say that that was the case in this case.
But didn't you just say the stop was clearly pretextual and didn't you have tinted windows? So and again, in response, I think in reaction to Justice Swinland's point, didn't you say the stop was pretextual initially?
I said that, judging by the totality of the circumstances, it's our position that the stop was pretextual. And again, I direct the court to the video evidence where,
We looked at the video evidence, and we have a dash cam that shows us exactly what the trooper sees that we see.
Correct.
Right? You see the motor vehicle, and I can understand that you might now have some criticism of the authorization rule, but there is an observed traffic violation, and so again, I'm still wondering what do we do with the fact that we have what we have and we see what he saw, and to the extent that there was an observed traffic speeding and lane violation, what do we do with that?
well, I think we can look at that in comparison to his later remarks, which in his later remarks before the grand jury, he suggests that this was some type of egregious speeding incident and that the car went over the lane. And in retrospect, when you look at the dash cam, I mean, it's going around a bend in the highway and barely touches that. It pulls over, reasonably. And I would suggest to you that we need to look at what happens thereafter to maybe put some of those dash cam videos and his decision-making at that point into context. And really, the important part.
I thought your brief was a little strained because you barely mentioned that the guy was an Uber driver, and you say, well, they treated the white passenger differently. And clearly, they treat the Uber driver different than the passengers.
This isn't a run-of-the-mill Uber driver either, right? And yet, they're so very willing to accept his
Does it matter?
odd suggestions. I
That it
think
was-
it does
yeah.
matter.
Okay, so explain that, yeah.
I think the fact that they're very willing to suggest this odd suggestion that he's a hood Uber driver and then turn their back to him for minutes at a time after that, and to let him, while they're approaching the car, go through his pockets and manipulate his phone and things like that nature, in contrast to the way Mr. Gelin and Mr. Lockett-Simmons were treated, I think that evinces some level of implicit bias, certainly enough to raise a rebuttable presumption along with the statistics that he should have been allowed to.
Only if we find the observation of the backseat passenger to be not credible, right? So if the observation of the backseat, your client, that he's moving around, which I think springloads how the police treat the backseat passenger, at least facially, if we think that he's making this up, it's a different story. But wouldn't that be a significant factor in the analysis?
Yeah, that might be a turning point of the investigation, but I think all of the evidence and the statistics can actually shine a light on what he's thinking when he interacts with the backseat passenger, at least implicitly. I don't think it becomes irrelevant by the fact that it happens after it, because it's still demonstrative of the
Can I
mindset
ask
that he
you,
has.
sorry, about the statistics? Why are the relevant, excuse me, statistics the instances in which this officer has pulled over Black or Hispanic drivers?
Why is,
That this driver was white?
again, I don't think that it's a one-for-one comparison. When you look at the statistics, the idea is that they could establish that somebody is prone to act with implicit bias, that that's something that's within.
So it doesn't really matter the context. It's just these traffic stops, even though this particular traffic stop was of a white driver, in general, this officer stops Black people more often than he should, given the demographics of the communities he's serving.
Right, and that would.
What is your authority for the fact that that's an apples-to-apples comparison?
Really, Van Rader and Long, I would suggest that those cases, to me, in
But
my
those
mind.
cases, well, at least Long is about a traffic stop, so it makes sense statistically to compare this officer's stop in this situation to compare it to his stops in other situations. What your scenario is more of a Van Rader stop, right? It's more of a, like, how are you treating pedestrians almost? They happen to be in the car and not walking, but did your statistician look at that?
No, I don't think he looked at that, but I would
Is that a
suggest that.
problem for you, or do we just accept it? You know, racist in the context of a traffic stop, therefore racist in the context of passenger frisks as well.
I think that the traffic stop statistics demonstrate that there's an implicit bias residing with this officer that's affected his decision-making process, and his decision-making process affects more than just the stop. It affects the subsequent investigation, and Van Rader talks about that word too. It talks about not only the stop, but the decision-making process and the subsequent investigation. And I think that's an instance here where we have statistics that demonstrate his decision-making process in addition to evidence of his decision-making process, which evince further suggestions of implicit bias. I think you have to consider it all when you're asking a litigant to make a rebuttable presumption, because these, like this court has reflected from the beginning, it's a difficult thing to prove somebody's bias, you know, and so we need to look at all the circumstances that could
So
reasonably speak to that.
if it's implicit bias, it's a long way from egregious police misconduct, correct?
It's egregious.
Under our case, under Owens, right?
It's egregious in that I think really any unfair violation of law enforcement like that.
That's why you want us to change the precedent, because you don't win under our present precedent.
I disagree with that, because I think the police knew that Mr. Luckett Simmons was on probation before he
I said,
searched them.
I meant Olson, not Owens, but you think,
I don't think I'm asking this court to change its precedent. I think I'm asking it to allow the long lower motions at a probation violation hearing, because that's really the only just outcome that could take place in a case like this.
That would require us to overturn Olson.
I'm sorry, Your Honor?
That would require us to overturn Olson. That's what you're arguing, isn't it?
No, Olson only applies to Fourth Amendment searches and unreasonable searches by its own terms.
Olson says exclusionary rule, and it also dealt with the Fifth Amendment. I get the clever lawyer in, but let's not do this.
Okay, yeah, I think that's my honest take on it. I think that they talk about the Fifth Amendment by analogy, but I don't think that decision was applicable to Equal Protection Clause claims. In any event, Laura wasn't decided until after that fact, and there's nothing within that decision, Olson, that foresees a new basis to move to suppress evidence and forecloses it. Certainly, I would suggest that it doesn't apply to Equal Protection Clause claims at all. And to the extent that it does, it's certainly distinguishable, especially by its own exceptions that it creates for egregious misconduct or conduct that shocks the conscience, which I think, even in a case of implicit bias, it's a little bit conscious shocking to consider the different stakes adhere for a person at a disadvantage like Mr. Gelin. And Justice Lowy, I know I didn't get to your question about the information technology and things of that nature.
I'm gonna ask the appellee about that.
All right, fair enough.
Okay.
Thank you.
Thank you very much. Okay, Attorney Lynch.
Good morning, may it please the court. Travis Lynch, Assistant District Attorney for the Commonwealth. You would have to overturn Olson for you to grant this.
Oh, would we? Do you think that a traffic stop that's tainted by racist profiling would constitute egregious police misconduct?
Not necessarily. And let me just say that I think that paragraph in Olson is really talking about, I mean, the court doesn't actually say in Olson that the court would use the exclusionary rule if there was actually egregious misconduct. It's just saying this case, Olson doesn't have it.
Okay, so what do you take to be egregious police misconduct that would take my analogy?
Sure. I think in,
Police know Gaziano's on probation.
right.
They go to his apartment. They say, we got him now, and they just kick in the door.
So I think the paragraph in Olson that we're discussing,
Does that constitute egregious police misconduct?
yes, because then the police would be exploiting the fact that the person, their target, is on probation. This is what Olson is contemplating or left open. Olson actually doesn't even say we would suppress under those circumstances either. It simply says maybe we would suppress if the police knew.
Okay, assume that we take that hint from Olson.
Right.
And we don't just say it's open-ended, and we do say there is at least some rules here, right?
There is, I think, a hypothetical case where the police know that the target of their misconduct is on probation, and they are intentionally trying to jam them up at a violation of probation proceeding.
All right,
That's
what-
essentially what we're trying to,
All
that's
right,
what we're concerned
What
about.
about an equal protection violation? Police know that someone's on probation, and the police officer has a bad Laura Long Van Rada history of pulling over minorities. Is that egregious police misconduct?
Only because the person knows that, the police officer knows the target's on probation.
So
That's-
you can target somebody who's black so long as you don't know they're on probation?
What I'm saying is that we have to consider the purpose of the exclusionary rule, which is deterrence. And Olson already said that the deterrence rationale is not served by excluding evidence in a violation.
But practically speaking, and I was prior to this as a trial judge, someone is on probation for a very serious crime, right? Say armed robbery. They're on probation for 5 years. The underlying offense or the new violation is, possession of a switchblade, just to use a hypothetical. They pull over the person, they get some relatively minor offense, and they go in front of a judge on a violation of probation for the armed robbery, and they're subject to any crime, any sentence up to life, and they could get 20 years, versus the misdemeanor that would be the exclusionary rule purpose. Where's the deterrence in that? All right, you got me. I'm not gonna, the misdemeanor's out, but the guy's serving 20 years. Where's the deterrence?
On the hypothetical that you just outlined with a possession of a switchblade, I mean, I don't want to fight the hypothetical, but I don't see anyone getting 20 years for that. I mean, I know that they're being sentenced on the underlying offense, but as a practical matter, that's not going to happen because the judge isn't going to send somebody for 20 years for having a switchblade as their
No,
violation.
they're being sentenced for the,
They're being
they're
sentenced,
given the grace of probation, as the case law says.
right?
They don't conform their conduct to the requirements of law, and now they're being punished on the probation violation, not the underlying offense. That's what the law says, at least.
I would just again say that in Olson,
So what does Olson mean, if it means anything?
Olson means that there are different interests in different types of proceedings. The interest at the violation of probation is to check on, or to make sure that we have all of the reliable evidence available to supervise the probationer to see if they violated their probation.
Even if that evidence was obtained through a violation, through targeting somebody because of their skin color, you don't think that constitutes egregious police misconduct or something that undermines the integrity of the judiciary?
The exclusionary rule, I'm sorry, when this court in Laura decided that the exclusionary rule was a remedy for an equal protection violation, it cited directly to the deterrence rationale. There's references to the judicial integrity rationale.
Right, which were not implicated in the Fourth Amendment context, but I'm asking you the question. In the context of somebody being targeted because of the color of their skin, doesn't that undermine judicial integrity? It doesn't happen in the Fourth Amendment context, but does it happen in the context of somebody being targeted because of who they are?
But that's not why the court adopted the exclusionary rule in Laura. In Laura, the court cites mainly to the deterrence rationale. So the underlying claim...
Talking about Olson. Olson says in the Fourth Amendment context, the judicial integrity is not implicated. I'm asking you in terms of the equal protection argument, isn't judicial integrity implicated if we allow evidence to be used to revoke somebody's probation in order to send them back to prison based on the color of their skin effectively?
No, and I say that because in Laura, the court relies on the deterrence rationale to justify having the exclusionary rule be a remedy for this type of claim at all. That's my answer to your question.
What branch of government is the probation department?
They're in the judiciary.
Right.
Right, but we already said but our main point in using the exclusionary rule
But it's
is
not
deterrence.
the only point, right?
It's the main point.
It is usually in the context of the Fourth and the Fifth and maybe even the Sixth Amendment, the main point. But is it not possible that in the context of race that it's different and that the exclusionary rule, what's your best argument that it shouldn't be used in this context other than telling me that in the Fourth Amendment context it's not used?
Because Laura, again, relies on the deterrence rationale to justify suppressing the evidence in the criminal case.
And that was a Fourth Amendment violation?
Laura, I'm talking about the case that created the equal protection motion to suppress.
I see, okay.
So in Laura itself, the court says, we think that this type of motion to suppress will deter this type of misconduct. So in the criminal case, the rationale is deterrence. Here we are in the violation of probation. We're not concerned about the deterrence rationale here. That's what Olson says.
But shouldn't we be concerned about judicial integrity because the probation department, the member of the judiciary is coming to us and saying, this person violated the law, please revoke the probation, right?
No, because in Laura, that's not the rationale for doing so in the criminal case.
So is your point then that if there's a suppression issue, and the purpose of the exclusionary rule is deterrence, then in the underlying probation matter, the evidence would be admissible. In the present arrest, it wouldn't be, but it's different if the police officers who pull the person over know they're on probation at the time of the seizure.
Right, that's the possibility that's left open in Olson.
Then let's go to what I think is the amici point, which is it's a whole new world now. People have information at the tip of their fingers, and it's not like it might have been, oh, I remember that person was on probation because I was in court when they were sentenced. Now there's information right there, a keyboard away. So does technology require a second look here?
I don't think so, because again, the only thing that would make a difference is the officer's knowledge that the target is on probation. I don't think you need to reach that question in this case, because there's no evidence, as far as I recall from the record, that the trooper knows that Mr. Gelin was on probation.
Well, the point is that perhaps we should reconsider Olson and Rainey, because the exception in Olson is now possible almost all the time.
Well, just because it's possible all the time as a hypothetical matter doesn't mean that it actually happened in this case. There's no evidence in this case that that happened. I'd also note, I believe there was an SJC case that was dismissed as moot, where I believe that same question was raised just a few years ago. It was Commonwealth against Velasquez, SJC-12788. I mean, I just glanced at the briefs in that case. I think that issue was mentioned there. And then there was another case that was in the appeals court that was decided recently, Farmian Williams, which is 22P373. And the defendant in that case sought direct appellate review, DAR 28848. And the court, this lineup of the court decided not to take that case for whatever reason. I don't think this case, this record squarely presents that abstract question. So I don't think that this case presents an occasion to reconsider that aspect of Olson. And
if there were evidence, though, we wouldn't even have to maybe reconsider Olson, because if you had a trail of the trooper going back to his MDT and inputting the bona fides of the passenger or the rear seat passenger, you'd have because he does get the information that he was just released, and that could hypothetically make him go look him up, right? But
Right.
you'd have a trail of that.
You would, yes. So if anything, it would be easier if a defendant, tried it, to make a record to get within Olson. But I don't think that that's here. So I don't think the court needs to decide that question here.
How should we define egregious police misconduct?
As I said before, it should be defined in terms of the police officer intentionally attempting to exploit the fact that the probationer target is on probation, because, again, that's what Olson states, or that's what I think Olson says. There was a suggestion that the Olson rule itself somehow creates disparate impact. I don't think that claim has any merit, because I don't think that this court intended for there to be disparate impact by the court saying the exclusionary rule won't apply at a violation of probation. I just wanted to point that out. There was also an interesting letter filed by the BBA, which I think raises a variety of interesting practical problems that would occur if we started having these motions to suppress in violations of probation hearings. Because, they say it would be really inefficient if we started having these motions to suppress that were both in the new criminal case and in a violation of probation. So they suggest that we should have tracking, but we generally don't have tracking in violations of probation. And I'm not primarily arguing all this efficiency as a reason not to change the rule. But it's a factor to consider when we're talking about a stare decisis argument. I would just note that in this case, the violation of probation was concluded within a few months of the new indictment being returned. The motion to suppress took until March of 2023, this year, to be resolved. So that's more than an extra year of litigation in a violation of probation proceeding.
And we've already said that that judges shouldn't track. We've said that before.
Right.
I don't want to lose you before, because we didn't get a chance to ask Attorney Murphy about the sufficiency claims. Understanding that it's not the full range of rights and burdens that we have at trial, where you have situations like this, back to Justice Gaziano's point, where you can get hit pretty hard on the probation sentence for the violation. Should we have more than we have here in terms of not only the contraband but also the firearm and whether it was operable or not?
No, it's just a preponderance of the evidence standard. I mean, the hearsay was found to be substantially reliable. A rational finder, I mean, it's not proof beyond a reasonable doubt. We all
No,
know.
it's not.
Right.
I'm sorry, go ahead.
Oh, please, see, you're asking just what I'm interested.
It's not, but we have witnesses that are the conduit to whatever preponderance of the evidence or the quantum of proof standard is applicable to the proceeding. And why should we change this dramatically, what the witnesses get to say in a probation violation that we wouldn't let them say in a criminal matter? Again, I understand it's not the same, but we're going from one here to the other, where you made expert testimony here and you don't need expert testimony there.
Well, I mean, I'm not even sure if in a civil case, if we were proving it to the ordinary, like in a regular civil case, I think this evidence would be sufficient if we were proving a criminal violation, to do the regular civil preponderance standard. And
But, we talked for a few seconds about tracking, and Justice Gaziano raised a hypothetical about the incredible consequences of a probation violation hearing. I see it on lack of license, I see it on possession with intent. But operable, isn't there just some line in evidence that it was loaded, the firearm was loaded? Is there anything more on operable?
I believe, I apologize if I don't remember. I thought the troopers said they thought it was operable.
Right, and then, well, it's loaded.
Right.
Is that, I guess I'm just repeating Justice George's question. That seems a little thin for the no tracking, huge implications.
That may be.
I want to just go back to your definition of egregious.
Right.
It seems awfully narrow, doesn't it? Egregious police misconduct is only a situation where the officer knows that the defendant or the defendant's on probation. Aren't there other ways that police could act in an egregious manner?
Maybe if they tortured somebody, that might be egregious, but that's
Well,
not what we have here.
Yeah, I don't think we have to go that far,
Right.
actually. No, I mean, situations where people are, the Fourth Amendment issue, kicking down someone's door knowing that they can do it without any kind of repercussions. Pulling somebody over because of their skin color, knowing full well that the person is black and just wanted to see what was going on with that person.
Again, I do tie it to the fact that there's no evidence.
No, I understand. And I just want to make sure, and this is a hypothetical, I understand that that's not what you argue is going on in this case. I'm asking, what should we be looking at with regard to what egregious police misconduct means? I'm just curious as to whether you're actually saying that because Olson talks about that one particular situation, that's all egregious police misconduct is.
For present purposes, yes.
Okay.
I wouldn't go any further than that.
Okay.
I'd ask that you affirm.